Thank you so much for joining us for the May edition of SKO University Stolkeen and Ogden's series of free monthly continuing legal education presentations on trending legal topics. We appreciate you taking the time to be with us for a discussion of what employers should know about vaccines in the workplace. My name is Ben Feaster. I'm counsel to the firm in the Lexington office, and I am part of the healthcare practice group, where I primarily practice in regulatory healthcare compliance. My co-presenter today is Stephen Clark. Stephen is a partner in the firm's Louisville office and a member of the Labor and Employment Practice Group. Before we get into the substance of today's topic, there are some housekeeping items we need to address. At some point during the presentation, please send your first name, last name, state in which you are licensed, and your bar number to Renee Lamb, the firm's business development manager, in the chat box. You can also email this information to Renee at renee.lam@skofirm.com. This session is being recorded, and the video will be edited and posted on Stolkeen and Ogden's YouTube channel. Following the conclusion of the program, you'll be sent an email with activity numbers for Kentucky and Indiana so you can claim your credit. This course is worth 1 hour of CLE credit. The email you'll receive will also contain a link to a brief survey about today's program, which will help us to provide tailored educational topics in the future and evaluate today's presentation. Today we'll be talking, as I said, about vaccines in the workplace and the way employers can develop policies to help them comply with applicable law and to help encourage employees to receive vaccinations. Well-crafted, thoughtful policies will be a big part of businesses being able to return to normal after, as the COVID pandemic continues to wind down. First, we'll talk about the legal framework through which vaccines made their way to the public. We'll also talk about types of vaccine policies and the laws that will impact employers in their decision-making process relative to those policies. We'll also discuss some HIPAA considerations that workplace vaccination policies can present. And finally, we'll touch on Kentucky's recently adopted COVID liability shield law, which has been in effect for a little over a month. First, let's start by talking about the status of the vaccines. There are, as everyone on here probably knows, there are 3 vaccines being used in the United States right now, manufactured by Pfizer, Moderna, and Johnson & Johnson. Each of these products has been authorized by the FDA for what's called emergency use. There have been clinical trials for all the vaccines that show really good efficacy, minimal to non-existent side effects, but the vaccines have not received full and unfettered FDA approval yet. Under the statute that governs the emergency use of vaccines and other products, which is on the screen now, individuals who receive the vaccine are required to be informed of the option to accept or refuse administration of products, the consequences of any of refusing administration of the product, and of the alternatives to the product that are available, and of their benefits and risks. This provision has not been litigated or interpreted by the courts, either with regard to COVID or any other previously existing vaccine. So we're left to speculate and guess a little bit about what precisely this means. But one possible interpretation of this provision is that vaccines given emergency use status can't be mandatory because it says that recipients have, quote, the option to accept or refuse. However, this is subject to interpretation, and as you will see, there are some laws that permit a more or less mandatory vaccine policy with exceptions that we will get into later. The phrase, the consequences, if any, of refusing the vaccine is also subject to interpretation. That could be referring to the medical consequences of refusing the vaccine, such as the fact that you might still get the disease it's intended to prevent, or it could refer to the consequences an employer might place upon an employee if they don't receive the vaccine, such as being required to continue wearing a mask while vaccinated colleagues are not subject to that requirement. We will continue keeping our ears to the ground and provide updates should the court or the FDA provide additional guidance on this point. And then, of course, if and when the vaccines receive full FDA approval, this caveat will no longer apply. One topic that goes hand in hand with the emergency use status vaccines is employee hesitancy. What we've seen in the real world is that at the outset of the vaccination campaign, that there was some hesitancy from folks who I guess wanted to take a wait and see approach and make sure everything seemed to be working well. And as the rollout continues to go well, we've seen those numbers drop. As the slide notes, in January, hesitancy was almost 30%, but it's dropped to closer to 20% in March and has probably continued to go down since then. The highest for hesitancy include construction, oil, gas, and mining, and the lowest is educators, which may be, makes sense given that they are in classroom and were provided an opportunity to be vaccinated at a very early opportunity in the process. With regard to healthcare occupations, the highest hesitancy occupations are medical assistants, EMTs, and home health aides, while pharmacists have the lowest hesitancy. And there are several reasons that people assert for vaccine hesitancy, and as this slide shows, many of them are concerned about side effects, don't believe the vaccine is necessary, they don't trust vaccines in general, they don't trust COVID vaccines specifically, or waiting to see if it's safe. And as you can tell, some of these reasons are more amenable to education and persuasion than maybe others might be.
Okay, thank you, Ben. And now that Ben has given you the background on the vaccine's current status and issues with employee hesitancy, I'm going to start our discussion on the topic of employer-mandated mandatory vaccinations. And due to the CDC surprise lifting of the mask mandate last week, now is as good time as any to evaluate your current vaccination policies or to consider enacting one if you haven't done so yet. And as this slide shows, as you're considering your policies, numerous laws are implicated. These include the Americans with Disabilities Act, or ADA, the Genetic Information Non-Discrimination Act, or GINA, and Title VII's prohibition on religious discrimination. So basically, you can see from the slide, this is an alphabet soup of every major federal labor and employment law, and there will be a lot of acronyms thrown around in today's presentation. We'll try to avoid it to the extent we can, but it's kind of necessary. Additionally, some state laws like workers' compensation and a recently passed Kentucky Senate bill could be implicated by your vaccination policy. So we'll walk through those as well. And a good starting point for a discussion of the laws implicated by employer-mandated vaccination is guidance issued by the Equal Employment Opportunity Commission, or EEOC. This is a good starting point because the EEOC is the federal agency tasked with enforcing several federal anti-discrimination laws you saw in the previous slide, such as the ADA, GINA, or Title VII. So after the CDC surprised everyone by lifting the mask mandate back on the 13th, the EEOC stated its intention to draft new guidance, but it has not been done. It could be any day now. But for the time being, this December guidance is operative, and it's one of the most thorough and extensive guidances we have dealing with vaccination. So employers do want to familiarize themselves with this. So generally, the guidance suggests that employer-mandated vaccination is lawful, but it is subject to the employer's duty to reasonably accommodate disabled employees under the ADA and the employer's duty to reasonably accommodate religious objections under Title VII. And we'll get to those disability and religious exemptions in a little bit, but first I'm going to start with another topic addressed in the guidance, and this is related to the ADA. So the ADA prohibits employers medical examinations of their employees or of asking disability-related inquiries of their employees, unless those medical examinations or disability-related inquiries are job-related and consistent with business necessity. And I'll say that again because it's a mouthful. The ADA prohibits employers from conducting medical examinations of their employees or asking disability-related inquiries unless job-related and consistent with business necessity. So on this topic, the guidance clarifies that administering the vaccine itself is not a medical examination because no medical information is elicited from the employee from merely administering a vaccine. So an employer who self-administers a vaccine or teams with a contractor to administer the vaccine to its employees is not conducting a medical examination that could potentially run afoul of the ADA. However, the guidance goes on to say that an employee that's being vaccinated will necessarily have to answer certain pre-screening questions that may elicit disability-related information that's protected by the ADA and GINA. To illustrate this, if you think back to when you got your vaccine shots, you were probably handed a clipboard and a checklist with a bunch of pre-screening questions. And this would have included disability-related questions, such as whether you have an immunodeficiency disorder, or it may have included genetic information questions dealing with your family medical history, and if there's any reason that would prevent you from safely receiving the vaccine. So the EEOC's December guidance states that these types of questions can only be asked by an employer or a contractor to the employer when the questions are job related and consistent with business necessity. So a question is considered job related and consistent with business necessity when the employee's failure to answer that question and therefore to receive the vaccine would present a direct threat to himself or others in the workplace. And an unvaccinated employee is considered a direct threat when he presents a significant risk of substantial harm to himself or others. So under this standard, an employer who administers vaccinations or uses a contractor to do so is not without legal risk. An employee who primarily works remotely or whose job duties require little to no contact with others may argue that they are not a direct threat to others in the health place or the workplace and should not be required to answer these pre-screening questions or be vaccinated. So employers might ask how they can avoid these concerns with pre-screening questions and being entangled in all of this. And one way would be for the employer to decide not to mandate vaccination at all, but to encourage it instead. Or the employer may maintain a mandatory vaccination policy, but instead of administering it themselves or doing it through a contractor, they could allow vaccination to be done by a third party, such as Kroger or CVS. And because the employer themselves would not be asking the pre-screening questions, they would not be eliciting disability-related information risk that they would violate the ADA in this regard. So as I mentioned before, the EEOC guidance also deals with employers' duty to reasonably accommodate employee disabilities. And so in this context, an employee disability would be a COVID-19 vaccine-related disability. Some potential examples of this would be known allergies to particular vaccine components, prior severe reactions to vaccination, a weakened immune system, or immunodeficiency disease. And there's even case law to suggest that an employee's severe anxiety related to vaccination could constitute a disability sufficient to require the employer to engage in the reasonable accommodation process. So once the employee's claimed medical condition is verified, at that point, the employer has a duty to engage in an interactive process with the employee to determine if a reasonable accommodation is feasible. And employees are not entitled to the accommodation of their choice. So using the example of a line worker in a factory, he may request a position that would lessen his contact with others, such as an administrative position in an office and off the manufacturing line. And the employer may consider this possibility, but is not required to meet the employee's exact request. Further, the employee is not required to make an accommodation that would constitute an undue hardship to the employer. Using the line worker example, if it would be difficult or expensive to retrain the employee for that administrative position he requested, the employer need not offer that accommodation. It would constitute an undue hardship. The employer might determine in that instance that a more reasonable accommodation would be moving the employee to the end of the manufacturing line and placing a plexiglass barrier between him and other employees, or requiring him or other employees around him to wear masks. And employers can only exclude employees from the workplace if that employee constitutes a direct threat to others. So even then, the employer should explore, if no reasonable accommodation is impossible to keep that employee in the workplace, the employer should explore whether remote work or leave are possibilities before terminating the employee's employment. And we do not have post-COVID case law on the duty to reasonably accommodate vaccine-related disabilities yet, but I'm going to turn it back over to Ben, who's going to discuss some examples from some pre-COVID case law relating to other vaccines that help illustrate how these requests for might play out in real life.
Yeah, so as Stephen noted, three big things under the ADA, prior case law developed under the ADA, is that in order for a policy to be permissible, the policy must be job related and consistent with business necessity, must be applied in a non-discriminatory manner, and the court will also look to see whether the employer has made reasonable accommodations for an employee's disability. And we'll talk about a few cases that illustrate some of those things in the pre-COVID realm. Again, there's not been much COVID case law developed yet because it's relatively new and things are still being litigated. But these prior cases on similar vaccines and similar policies will help people understand kind of what the courts are looking for. The first case listed there is Husvet v. Alena Health Systems. That's a 2018 case that came out of the 8th Circuit. It involved a rehabilitation facility employee who had not received a measles, mumps, and rubella vaccination. This employee was in a position that required her to be in close contact with individuals with compromised or fragile immune systems. She expressed some common hesitancies that her health might be negatively impacted by the virus, but did not provide any medical documentation that she had any of the conditions that Stephen mentioned that might warrant an accommodation. Ultimately, she didn't receive the vaccine and was fired. She filed a lawsuit for discrimination and retaliation under the ADA and a corresponding Minnesota state law. The trial court granted the employer's motion for summary judgment, and the circuit court ultimately upheld that. And in doing so, the court pointed out that the ADA permits employers to undergo medical examinations and inquiries, as we've noted already, if they're job related and consistent with business necessity. This test here was satisfied, according to the court, because of the employer's overarching policy to ensure patient safety and because of the employee's specific contacts with immunocompromised patients. The next case is Shimura v. Monongalia Health Systems, which is out of a West Virginia federal court. It involved a registered nurse who was working in a hospital that had implemented a mandatory influenza vaccine program. The policy, by its terms, allowed employees who believed they had a medical contraindication to submit an exemption request. The employee submitted such a request based upon what she asserted was a severe latex allergy and her concern that there could be latex in either the vial or the needle. However, again, she did not provide medical documentation of this specific, of her alleged allergy. She presented a doctor's note that said she had some sensitivities. However, the doctor did not actually conduct any allergy testing, and she hadn't undergone it elsewhere. I think it was in 2015, she received a latex-free vaccine, but she reported that she still had some allergic reactions, which again, weren't backed up by any documentation from her physician. So the next year, when she requested an exemption from all vaccines, that request was not granted, and she was ultimately fired. This was a trial court case, and the trial court granted summary judgment to the hospital and asked the question whether the employee had made out a prima facie case of wrongful discrimination. And at the stage of the litigation, all the employee had to show is whether she raised a reasonable inference of unlawful discrimination. And the court concluded that she did not, because the hospital had appropriately accommodated her request to receive a latex-free vaccine, and the documentation that she submitted supporting her purported exemption was severely lacking to non-existent. So the court concluded that it was okay for the employer to request proof justifying the applicability of an exception, and for an employer to take action if that documentation is not reasonably provided. Then the last case on this slide is called Ruggiero versus Mount Nittany Medical Center. That's a Third Circuit case out of Pennsylvania. This case involved another registered nurse at a hospital. She had been diagnosed with severe anxiety and eosinophilic esophagitis, which is a esophageal condition that makes eating and maybe even social interactions difficult to very stressful for this person. The hospital here instituted a policy that all clinical employees be vaccinated with the tetanus, diphtheria, and pertussis vaccine. The employee here requested an exemption, and she provided a doctor's note pointing out those medical conditions I mentioned and noting that she was, quote, terrified of the vaccine, but it did not specify which vaccine contraindication that she met. Ultimately, she suggested to her employer that she permitted to be a mask, which she that she be permitted to wear a mask, which she contended other unvaccinated nurses were permitted to do, but she was ultimately turned down in that request and then fired. She filed a suit alleging that her employer failed to reasonably accommodate her requests. Trial court initially granted the hospital's motion to dismiss this case, but the Third Circuit reversed. And in doing so, the court noted that at the stage of the litigation that this was in, the plaintiff's allegations need to be taken very seriously. And once that she has provided notice of a disability and requested an accommodation, the employer is required to work together with the employee to determine what accommodations might be necessary. The court then determined that the plaintiff's complaint raised plausible inference that the hospital failed to engage in this interactive process. They rejected, without proposing any alternative, either of her request for exemption or permission to wear a mask. So ultimately, she was her claim was found to have merit and permitted to proceed. As Stephen touched on a little bit earlier, there's also EEOC guidance related to religious exemptions. Title 7 of the Civil Rights Act prohibits employment discrimination based on a number of factors, including religious belief. In popular thought these days, there are a number of objections to the COVID vaccine that have been described as religious, but the courts have a pretty specific standard as to what constitutes a religious belief in the employment context. And that includes spiritual ideas about life, purpose, and death, and does not include general objections to vaccination safety that may become wrapped up in a person's religious beliefs. A few cases illustrate what this looks like in practice. The first is Dockery versus Maryville Academy, which involved an employee who worked at a child welfare agency and identified himself to his employer as Jewish. His initial schedule required him to work on Saturdays, and he didn't initially object to that. He was eventually transferred to another facility and required to work on Fridays and Saturdays, and then requested to have those days off due to his observations of the of the Sabbath. When he was deposed for this case, he referred to his religious beliefs as a culture versus a religion, but then went on to refer to his culture in expressly religious terms. The court noted that while the employer cannot question the validity of a religious belief, they need to determine whether the belief is sincere and meaningful and occupies a place in the life of its possessor parallel to that filled by an orthodox belief in God. And if that's the case, then the employer must reasonably accommodate the belief unless doing so creates an undue hardship. One interesting thing that this case points out is that employers are permitted to consider whether the employee has acted in a manner inconsistent with his or her professed beliefs. This occurred here when initially the employee didn't object to working on the Sabbath, and then later, after a transfer to another department, did object. The court pointed out that the employer who requested more information from the employee about why this was, that was an appropriate thing for the employer to do. The next case is called Adieye versus Heartland Sweeteners. It's out of the Seventh Circuit from 2013. And it involves an employee who is of Nigerian descent, and he requested several weeks of unpaid leave to go back to Nigeria and help lead his father's burial ceremonies. He reported to his employer that he believed if he didn't do so, he and his family would, quote, at least spiritual death. His request was denied and he was fired after he attended anyway. In this case, the court noted that in an intensely personal subject like religion, an employee's claims themselves are to be given great weight. The court noted that why the person holds the belief and questioning why that belief is held is not an appropriate question. In other words, the court said it wouldn't ask whether the employee had a, quote, conversion experience on one hand, or rather whether the beliefs could be attributed to culture and family upbringing. Instead, according to the court, the appropriate question is whether the belief is sincerely held. The next case is Shinzara versus Cincinnati Children's Hospital, which is a little closer to home for us here in Kentucky and Indiana. This involves an employee who was a vegan who refused to receive a flu vaccine as a consequence of her veganism and was ultimately fired and filed a lawsuit. The hospital moved to dismiss the complaint and contended that veganism was not a religion. But the court pointed out that the Equal Employment Opportunity Commission previously stated it would define religious practices to include moral and ethical beliefs as to what is right and wrong, as long as they are sincerely held with the strength of religious views. And again, this case arose out of the context of a motion to dismiss, which requires the courts to accept as true the allegations that the plaintiff has made. So at least at this stage, the court has indicated that plaintiffs are going to be given a fair bit of deference as to what their claims of belief are that would prohibit them from receiving a vaccine. And then lastly is Brown versus Children's Hospital of Philadelphia. This involved a mandatory vaccine policy at a hospital, which had both a medical and religious exemption. The plaintiff in this case tried to obtain an exemption, and the reasons she said she was entitled to one were because she washed her hands routinely and because she had no health problems due to her, quote, holistic health lifestyle. She also noted that she was concerned a vaccine could do her personally more harm than good. And these claims they echo some of the anti-vaccination rhetoric that has been seen with COVID and other vaccines. In this case, the trial court dismissed her lawsuit, and they noted that under Title VII, it's not sufficient to have a sincere opposition to vaccination, even if that opposition is strongly held. Rather, the opposition must stem from a religious belief. So I'll turn it back over to Stephen about the accommodations, what those might look like in practice.
So if an employee presents to you with a COVID vaccine-related disability or religious objection to the vaccine, there are any number of potential accommodations that could be made. And the best I understand is that reasonable accommodations under the ADA should be determined on a case-by-case basis. And there's no one-size-fits-all approach. You have to sit down with that employee and determine what their limitations are or might be. But that being said, there are a number of them that employers have instituted already. You see from the list here on the screen, you could have additional PPE, such as face shields or masks. The employee's workstation, if without undue hardship, could be moved to a location that minimizes their contact with others. The employee could potentially be transferred to another position that would minimize contact with others, or before hours or after hours work that might achieve the same result, or finally even remote work that guaranteed to remove an employee from contact with others. Now that we've addressed several of those applicable federal laws to consider when enacting a vaccination policy, I want to quickly address a Kentucky law that we've had a couple questions from employers about. This is Kentucky Senate Bill 8. this was passed through the Senate and sent to the governor. He didn't veto it, but after not signing it after a period of time, it was enacted automatically into law on March 28th, 2021. So this is the current law under Kentucky. And it states that employees, that the Cabinet for Health and Family Services has the ability to require immunization of individuals in the face of an epidemic. But this bill allows persons who write a written objection based on their religious beliefs or their conscientiously held beliefs to opt out of that mandated government vaccine. And as you can see, conscientiously held beliefs effectively ensures that really any citizen could opt out of such a vaccine. And so the question that a couple of employers have had is, does this open us up to legal liability for requiring a vaccine? And if you could contrast the Senate Bill 8 with Senate Bills 37 and 98, which were presented in the Senate and haven't received a vote, those bills would expressly prohibit quote-unquote employers from mandating vaccination. And that prohibition is not found in Senate 8. Additionally, the sponsoring Senator Mike Nelson from Bowling Green has stated to the media that the bill does not apply to employers. So nevertheless, employers may still fear that they would be subject to an employee's civil claim for wrongful termination in violation of a public policy based on this statute. However, those public policy claims must have an employment-related nexus to be actionable under Kentucky law, which is lacking here under the statute. So could such a claim survive a motion to dismiss? Perhaps that's possible in some Kentucky circuit courts, but currently it looks like this is not a particularly great claim for an employee to bring. And some other applicable laws that employers should consider when enacting their vaccination policies are wage and hour laws, such as the Federal Fair Labor Standards Act and Kentucky's wage and hour laws. So employers who require employees to be vaccinated should ask themselves whether that time spent receiving the vaccination is compensable work time. This isn't a settled question, but under Fair Labor Standards Act regulations, time spent by an employee waiting to receive medical attention on the premises or waiting to receive medical attention at the direction of the employer during the employee's regular work hours is normally considered compensable work time. So employers should ask themselves whether they're required to pay that employee's salary for the time spent receiving the vaccine and whether that should factor into their overtime calculations. Under state law, workers' compensation laws may be implicated. So employers who vaccinate employees themselves or bring in third-party medical providers as contractors should first consult with their workers' compensation carrier to ensure that any injuries resulting from the vaccination are covered under their insurance policies. And even employers who mandate vaccination but do not personally administer it or do it through a contractor should probably have this discussion with their workers' comp carrier. There is some limited case law on this subject that suggests that when an employer requires vaccination for work purposes, that complications arising from the vaccination arise in the course of employment and are compensable under workers' compensation laws. This is less of a concern if you don't require or mandate vaccination, but it still may be worth taking a look at if you are incentivizing or suggesting vaccination to your employees, because there's no law on this in Kentucky or Indiana, but there are a couple of states that have held that if an employer benefits from encouraging vaccination, that even then this could fall under the workers' compensation umbrella. Another potentially applicable law is the Occupational Safety and Health Act. That act has certain record-keeping requirements, and covered employees must log certain work-related injuries on what's called an OSHA 300 log. And so under new guidance issued by OSHA on April 20th, if an employer requires vaccination, if it makes it mandatory, then any adverse reaction to the vaccine is deemed work-related. And so under OSHA's requirements, work-related injuries that require an employee to miss a day of work or to receive some form of medical treatment beyond mere first aid must be reported on that OSHA 300 log. However, the OSHA guidance from April goes on to clarify that employers who merely recommend but don't require vaccination do not need to record adverse effects of the 300 law. Then finally, another law implicated by employer vaccination policies is the Fair Labor Standards, the National Labor Relations Act, which governs unionized workforces and collective bargaining. So, for example, an employer that's mandating vaccination should ask whether its applicable collective bargaining agreement authorizes a vaccination requirement or not. Unionized employers must also bargain collectively over matters that affect the, quote, wages, hours, and other terms of employment of their employees. And so it's likely that a mandatory vaccination would be considered to affect the terms of employment of union employees. And this would trigger a mandatory bargaining obligation with the union. So you'd have to give notice to the union and come to the bargaining table rather than an employer unilaterally enacting a mandatory vaccination policy. And that brings us to our next topic. I'll turn to Ben.
Thanks, Stephen. The trend currently that I think observers have seen among healthcare providers seems to be toward encouragement rather than a mandate at this stage, at least. Many healthcare workers who have background in science and medicine are able to articulate reasonable and evidence-based concerns about vaccination, particularly in reference to vaccines that have emergency use rather than full approval status. While studies and trials that have taken place have shown that these vaccines are very safe and very effective, it is true that they have not received full FDA approval. And so encouragement seems to be working, though, as vaccines tick up, but as the pace begins to slow down, as we've seen kind of in the population overall and among healthcare folks specifically, since they've had access to the vaccines for such a long period at this point, it may be that some employers might find it desirable to change those policies from the encouragement model to more of a mandatory model. There's reason to think, though, that healthcare employers might have more leeway in creating mandatory policies than, a factory, as Stephen used it as an example, or a restaurant or business, other type of business. As the cases we discussed a few minutes ago illustrate, healthcare providers on a routine basis deal with sick individuals and have a business purpose to protect those individuals. The Occupational Safety and Health Administration provided guidance applicable to mandatory flu shots, not COVID vaccines, but the logic is very similar. And in passing that guidance, they noted that the Occupational Safety and Health Act requires that workplaces be free from serious recognized hazards, which in the healthcare context could permit an employer to impose a mandatory vaccine policy, subject to some of the things that we've already discussed. Some case law that illustrates that is below. We've already talked a little bit about the Brown versus Children's Hospital of Philadelphia case, but in Robinson versus Children's Hospital of Boston, the hospital in question had in place a mandatory flu vaccination policy, which an employee who is Muslim objected to based on the presence of gelatin, a pork product, in the vaccine. The hospital offered an alternate vaccine which did not contain gelatin or other pork products, but the employee declined to receive that on some other grounds. The hospital also took efforts to find other positions within the hospital that would not bring her into contact with patients, but ultimately such a position could not be located. The court in this case concluded that the policy of mandatory vaccinations for those public-facing employees was reasonable for a hospital, and the requested accommodation to remain in that position without being vaccinated would create an undue hardship by increasing the risk of transmission to vulnerable patients. there are some current challenges ongoing that are specific to the COVID vaccine. As you might expect, though, those are in pretty early stages of litigation. We here at Skull-Keenan will work to monitor these cases and others and alert clients if in the event something significant occurs. But we can talk about these cases briefly and what they can tell us about these policies. In the first case, Legarreta versus Macias, the plaintiff is a county detention center worker in New Mexico, and the county issued a directive that all first responders, detention center employees included, had to receive a COVID vaccine as a condition of ongoing employment. The plaintiff filed a lawsuit and requested a preliminary injunction permitting his employer from taking adverse employment action for refusing to take what he called a non-mandatory unapproved vaccine, and he cited to the emergency use statute we've discussed a couple of times this morning. Plaintiff, however, did not detail his efforts to obtain any accommodation from his employer, and as a result, the court declined to grant the injunction because he failed to specify why he believed he was in imminent danger of losing his job, and because he had not received any discipline to that date. He had received I guess you could call it a talking to, but that the court believed did not rise to the level of discipline. The next case is the California educators versus the Los Angeles Unified School District, which involves a group of teachers and some other plaintiffs who filed suit and initially requested a preliminary injunction based on the emergency use status of the COVID vaccine that would prohibit Los Angeles' school district from requiring that they be vaccinated. They recently, within the last couple of days, they noted their intent to file an amended complaint. So that case is ongoing and may develop further. The school districts also filed a motion to dismiss. And then lastly, I don't believe this is an actual lawsuit yet, but this made news in healthcare circles. Houston Methodist Hospital announced about a month ago that they were going to institute a mandatory strict requirement that its employees be vaccinated. And at least one nurse that works there has indicated she's going to object and may file legal action. She indicated that she would want to wait until the vaccine is fully approved by the FDA. But also in some news reports, she seems to be reasonable and is willing to continue to wear a mask and face shield while the vaccine process is ongoing for full approval. So that may be a situation where a reasonable accommodation can be reached. But again, we'll continue monitoring those cases and update in the event that something significant occurs.
And so as we've discussed, there are a lot of legal concerns with mandating vaccination. So a lot of employers, the majority of employers, are opting for encouraging rather than mandating vaccination. For example, you've probably seen some of these in the media. I know Dollar General offers their frontline employees 4 hours of pay to get vaccinated, and Trader Joe's does 2 hours per shot. But these types of incentives are not entirely without legal risk. For backtracking for a minute, those employers who administer vaccination or directly contract with providers to administer vaccination, incentives that are more than de minimis may constitute coercion of employees to receive the vaccine. So they would be coerced into answering those pre-screening type questions and providing medical information or family history they otherwise would not provide in violation of the ADA or GINA. They would do this because they want to earn the incentives you've offered. To be safe, in that instance, you'd want to offer only de minimis incentives. There used to be an EEOC guidance on what constitutes de minimis. It was something like a water bottle or a $20 gift card, but that has been withdrawn. The anticipation is that the EEOC will allow employers to offer something greater than those limitations, like the 2 or 4 hours of pay, but we just don't know yet. But going back to, so when you have a voluntary vaccination program, you need not worry about coercion when you allow employees to go to third-party providers like CVS or Kroger. Because there's no coercion because then it's voluntary. And then secondly, there's no concern with violating ADA or GINA because the employee is answering those questions to a third party, not to his employer. However, even with a voluntary program, the ADA still requires employers to provide reasonable accommodation to disabled employees to participate in the incentives. So therefore, the employer will need to engage in the interactive process with the employee to determine a reasonable accommodation for the disabled employee to participate in the incentives offered for vaccination. So an example in this instance might be requiring the unvaccinated employee to watch a training video that outlines actions they can take to reduce the risk of contracting or spreading COVID within the workplace. Then after watching that video, they would be eligible for the same incentives offered to the vaccinated employees. Another issue when you're encouraging but not mandating vaccination is that employers will ask about their ability to track the employee vaccination. And that EEOC guidance from December explains that it is generally lawful to ask whether an employee has been vaccinated. This does not constitute a prohibited medical examination or disability-related inquiry under the ADA. So the thing to be careful about here is while employers may ask if an employee has been vaccinated, they should refrain from more probing questions, such as why have you not been vaccinated, or do you have a condition or disability that's going to prevent you from being vaccinated. And in order to receive our CLE credit for Indiana, we're required to include an interactive element in the presentation. So I'm going to quickly load our poll question so we can move on while that's up. And these confidential answers, so we won't see who's answered what to this question. Okay, and so our next topic is the current COVID guidelines. So as you know, the mask mandate was lifted for fully vaccinated individuals on May 13. That lift still does not include healthcare settings and public transportation. And it also, the CDC's guidance states that the mask mandate is still subject to state and local rules. So in Kentucky, Governor Beshear quickly followed suit, adopting most of the CDC's lifting of the mandate. However, Governor Beshear's order specifies that the healthcare settings, childcare settings such as daycare, K through 12 schools, correctional facilities, homeless shelters, and long-term care are still subject to a mask mandate. And then persons with immunodeficiencies should still wear masking. It's a little bit different in Indiana because back in April 8th, the mandate became an advisory, but still in state buildings and K through 12 schools, masking is required in Indiana currently. And then there were a few counties that had kept the mandate after the state lifted it. I think it was 3, and 2 of the 3 have now adopted the CDC guidance and no longer require a mask. And as of yesterday, Marion County, where Indianapolis is located, still had a mask mandate in place, but local officials there have signaled their intent to revisit that in the near future. So we could see Indianapolis mask mandate lifted soon. And then on the heels of the CDC lifting of the mandate, OSHA was one of the first agencies to issue new guidance. And they basically just said that following the CDC's guidance is sufficient under OSHA's workplace hazards guidelines. And so the official adhering to those will not create an issue with OSHA. And now I'm going to turn it back to Ben to discuss some HIPAA-related concerns with employer vaccination policies.
Thanks, Stephen. In the public imagination, HIPAA is a really broad statute that governs any and all mention of medical care, treatment, or conditions. And I think, funnily enough, we often see it trotted out as an all-purpose excuse to not do something or to do something when the person expressing that opinion about HIPAA just doesn't really feel like doing something. In reality, it's more limited than that, but it's still very important for employers to be aware of what HIPAA imposes upon them. In a nutshell, HIPAA governs the use and disclosure of protected health information by covered entities and their business associates. The typical covered entities that we think of when we think of HIPAA are healthcare facilities like hospitals and doctors' offices, also health insurers. There are a couple other categories, but those are kind of the main two. So most employers are not HIPAA covered entities, but many employers do utilize employer-sponsored health plans, which are covered entities. Under most circumstances, those employer-sponsored health plans are not permitted to share employee health information with employers absent the employee's authorization. There's one exemption to that requirement that is called the Public Health Activity and Purpose exemption, but it only applies if the covered entity is a healthcare provider providing healthcare to the individual at the request of the employer to conduct medical surveillance of the workplace or to evaluate whether the individual has a work-related illness or injury, and only if the employer needs such findings in order to comply with its obligations under regulations promulgated by OSHA or the Mine Safety Health Administration. So it doesn't exemption to the authorization requirement would apply in the typical COVID vaccination situation, but it could apply if there were alleged workplace transmissions going on in the workplace. There's, as I mentioned, there's strict limits to a covered entity's use and disclosure of this information. And one time when this comes up is in the instance of healthcare providers who are also employers. They provide health care to their employees. Maybe if taking UK here in Lexington, for example, if someone works at UK and goes to the emergency department at UK, UK parts of UK will have both employment, or one part of UK will have this person's employment records and the other part will have medical records. For employers who are in this dual role as covered entity and employer, the requirement for authorization still applies. The Department for Health and Human Services has stated that this does not give the employer the right to use medical records for employment purposes without an authorization in most cases. As we've talked quite a bit about today, the kind of two big ways you can enforce a employer policy is voluntary or mandatory, and really both of them, a voluntary request for a proof of vaccination where the employer asks as part of its policy, could you please let us know if you have been vaccinated? That generally does not raise any HIPAA issues because individuals are of course free to share their own health information as they see fit. However, the question arises, could an employer require that the employee execute an authorization for the disclosure of vaccine status? HHS has noted on several occasions that nothing in HIPAA would prohibit employers from obtaining authorization for that sort of thing as a condition of employment. But as a practical matter, this could create hard feelings and friction between employer and employee, and for that reason might not be advisable. And also, going that route, employers are still required to meet generally applicable employment laws that we've discussed today. And for instance, all the mandate must be applied uniformly, it must be job related, and must be a business necessity. Very briefly, there's another HIPAA consideration that I've noticed has come up recently, and that's in the use of web-based scheduling applications, which made the news in some states as being very difficult to access and utilize. But my experience in Kentucky and in talking to others found tools used by Kroger, UK Baptist, and other providers as pretty easy and user-friendly. But HHS noted that in some instances, the use of these programs might not comply with HIPAA and can inadvertently make vendors of those applications into business associates of the covered entities providing vaccinations. So HHS announced recently that it will use its discretion and will not impose penalties for non-compliance if the use of the application is in good faith. And they will determine good faith by looking at several factors, including use and disclosure of minimum necessary, using encryption and privacy settings, making metadata storage temporary, and ensuring that the vendor does not engage in the sale of the protected health information. Last thing to talk about today is related to Kentucky's recently enacted COVID liability shield law, which was passed as part of Senate Bill 5. This law shields business and premises owners from liability for alleged injuries arising from a COVID-19 claim. In other words, possible exposure to or transmission of COVID-19. The shield is not absolute, and I think that's the most important thing to take away from this portion of the presentation. It's available only to owners that follow executive action to prevent the spread of COVID-19 and does not apply if the conduct in question was grossly negligent, wanton, willful, malicious, or intentional. So in other words, back when indoor dining was not permitted under Governor Beshear's orders, a restaurant that allowed indoor dining would not be able to take advantage of the COVID liability shield if they alleged that they had contracted COVID while in the restaurant. It will be certainly a boon for owners, but will require some effort to obtain. Again, since this is such a new statute, it hasn't been litigated very much yet. But in regard to other immunity statutes, Kentucky's courts have held that the decision of whether immunity applies involves the determination of material fact, which of course means that a plaintiff will be able to conduct discovery related to whether the owner was complying with the executive directives or was acting in a grossly negligent or otherwise culpable manner. So even where the shield will ultimately is held to apply, businesses can expect some litigation expense for owners, and it puts the burden on owners to document their efforts to operate in a safe and compliant manner. Without maintenance of such records, it could be difficult to take advantage of the COVID shield law's protections. So we'd urge everyone to make special efforts to maintain that documentation. And then lastly, there's some question about whether or not it can be held to be retroactive. By its text, it says that the shield applies to any injury or harm that occurred on or after March 6, 2020, which is about a year before the statute was passed. In similar laws, we have seen that courts are suspicious of legislation that impairs an individual's ability to redress injury through the courts. But given that the General Assembly was very express in its statement that the law would be given retroactive effect, our expectation is that this retroactive effect will be upheld going forward. And with that, that will conclude the substance of our presentation. We want to thank you all for joining us today. Stephen and I and the